May it please the court, my name is Roberts, Roberts, Sarah, Sarah, and I appear on behalf of the defendant Ms. Stone in this matter. Ms. Stone was convicted under sections 317(1)(b) and 317(1)(e) of the Criminal Code after she attacked her abusive ex-partner. In my submission, I will refer to mitigating factors relevant to the offence and to my client. I submit that the appropriate sentencing range for Ms. Stone is 5 to 7 years imprisonment. I also submit that the offence should not be declared a serious violent offence. Your Honour, if I can direct your attention to Section 9 of the Penalties and Sentences Act, which highlights the relevant sentencing guidelines. In this part of my submission, I will be referring to Section 9(2)(f), 2(i), 3(g), and 3(h), and Sections 13, 13(a), and 13(b) of the Act. Ms. Stone is 45 years old. She has no prior criminal history. The case of Veen and the Queen suggests that such lack of antecedent criminal history might suggest that the offence is completely uncharacteristic of the offender. That is certainly true of Ms. Sparks. Furthermore, the case of the Queen and Burrell highlighted the impact of a guilty plea has on a case. In this case, Ms. Stone pleaded guilty when she was first arraigned, and I submit that this warrants significant reduction in her sentence. Ms. Stone also cooperated with law enforcement authorities as she surrendered herself to the police and made submissions to them regarding the offence. The case of Aaron Webber in 2000 suggested that this should yield a significant discount. I will now move on to the mitigating factors relevant to my client's personal circumstances. I would ask the court to direct their attention to sections 9(3)(j), 2(f), and 11 of the Penalties and Sentences Act. Your Honour, have you had the opportunity to review the psychologist's report? Great, thank you, Your Honour. The court-ordered psychologist found that Ms. Stone had a dysfunctional and abusive childhood. On top of that, she suffered abuse in her previous relationship with the ex-de facto partner. He would physically abuse her when she was helplessly drunk and unable to defend herself. It was found that she suffered 3 years of this physical and emotional abuse. This history of trauma and abuse has severely impacted Ms. Stone. She has become an alcoholic for the majority of her adult life, that is, and she has been left with a reduced capacity to make moral sound judgments. The psychologist found that Ms. Stone is more likely to seek retribution on those who do ill to her, and it is evident that the ex-de facto partner did such things. In the case of Queen and Ciaris in 1996 and the Queen and Verdins in 2007, it was found that mental illness of an offender might reduce their moral culpability. This principle was not exclusively applied to the most serious psychiatric illnesses, but to all mental illness. Therefore, it is relevant to this case with regard to Ms. Stone's mental health. I also asked the court to consider the emotional stress suffered by Ms. Stone when evaluating her moral culpability as suggested in Neil and the Queen in 1982. There is no doubt that her upbringing and abusive relationships have caused her severe emotional stress. The court should also consider that Ms. Stone's actions were out of character. In the case of Ryan and the Queen in 2001, it was considered that the court should calculate the offender's character without reference to the offence itself. So, but for her attack on her abusive ex-partner, Ms. Stone is of good character. She has several written references from the Townsville community group members she volunteers with to support this. They describe her as kind and caring, and they are in the court today to support her. I'd like to mention that whilst the Penalties and Sentencing Act does not mention the offender's health as a mitigating factor, the case of the Queen and Green in 1995 claims that their health is still relevant. The court should consider Ms. Stone's rapidly deteriorating vision, as it means imprisonment will have an exacerbated burden on her, as suggested in the Queen and Pope 1996. Eyesight is integral to the human experience, and we can only imagine the grief Ms. Stone is going through as she feels that slip away. It would have a significant emotional impact on Ms. Stone if her last years of having eyesight were spent in prison. Finally, I'd like to further explain my submission for a 5 to 7 year custodial sentence with no serious violent offence declaration being made. There are several cases that highlight the range for similar violent offences is 6 to 8 years. Those list of cases include the Queen and Beer in 2000. In that case, the offender did not plead guilty, so he did not receive a discount for that mitigating factor. He was sentenced to 7 years imprisonment and no serious violent offence declaration was made. Given that Ms. Stone has pleaded guilty and did so promptly, her sentence should reflect this, and it should be of a lesser amount than in the Queen and Beer. My client and I recognise the prospect of a serious violence offence declaration being made, and I'd like to direct the court to section 161B3 of the Penalties and Sentencing Act regarding this declaration. The court should consider the serious impact making such a declaration would have on Ms. Stone, as suggested in Arambojevic in 2000. We've already said that Ms. Stone's eyesight is deteriorating. If such a declaration was made and she had to serve 80% of her sentence before she was eligible for parole, it is likely that her eyesight could have completely deteriorated by this time. Furthermore, there must be some purpose for making a declaration of a serious violent offence, and that must extend beyond the mere violent nature of the offence in question, as suggested in the Queen and Collins in 2000. One purpose the court may consider is protecting the community. However, Ms. Stone is not a threat to community safety. In fact, she's an active member of community, as we've established through her volunteer work at Townsville community groups. And these group members also describe her as of good character and kind and caring. Ms. Stone is not dangerous. Ms. Stone is not dangerous. She is a victim of abuse who sought retribution on one of her abusers. Therefore, a serious violent offence declaration is not warranted. Your Honour, I have highlighted the mitigating factors that are relevant to the offence and to my client's personal circumstances, including her traumatic history of abuse. I submit that the appropriate sentencing range for Ms. Stone is 5 to 7 years imprisonment. I also submit that the offence should not be declared a serious violent offence. If there are no further Your Honour, if there are no further questions that I can assist you with, that concludes my submission. Thank you.